Welcome to our inaugural talk in the Innovation Series, Entrepreneur Toolkit. Tonight's talk is Business Strategies for Intellectual Property in the Knowledge Economy. My name is Bill Decker. I'm with the Office of Innovation and Commercialization. And the reason we're giving this talk is in our office we have, and I have to look this up here, we have over 850 US patents that are issued that we're managing. We have over 350 licenses for those patents. And so we've learned over the years that looking across different businesses, different patents, different ideas, that there are strategies that businesses utilize. And so just by sheer numbers, we've learned some of these strategies by working with our licensees, and we wanted to share those with you. We've also been able to use some of our contacts throughout the talk tonight. You'll be seeing quotes from entrepreneurs that are local to the area. We're going to provide this talk. You'll get their LinkedIn profile along with that. And these are people who wanted you attending this talk to learn some of the things that they've learned the hard way building their businesses. On stage with me, let me kind of go from my right to all the way to the right. We have Gary Schuster. Do you want to introduce yourself?
Yeah, I'm Gary Schuster. I've done a lot of things, which is good for entrepreneurs and inventors. I started out as a UCLA undergrad, certain I was going to go into politics, went to Harvard Law School, found out it was better to be an inventor than a lawyer a lot of the time, and started inventing. Essentially, the initial inventions were to solve problems that I couldn't solve as a lawyer. I was in-house at a web hosting company, and you can't solve a problem if it's originating in Eastern Europe, not with the courts. So I would come up with technical solutions. Now at 154 patents, so I'm still trying to catch up to UCSD, but I will at some point probably not catch up. That's really
good.
A lot.
Keep going.
I'd like to. Actually, Keith Silverbrook, the most prolific inventor, does have UCSD beat. He's over 1,000.
Oh, good, good. And further to the right is Greg Horowitt, if you want to introduce yourself.
I work with Bill and Paul and Gwen and the others at the Office of Innovation and Commercialization. But my background is I'm a serial entrepreneur. I'm a venture capitalist as well. I still run a venture capital firm here in San Diego. And I write books on the subject of innovation.
Okay, and throughout the talk, if you have a question, just raise your hand. We will have a time period at the end, but if you have an immediate need to ask a question, please do that. There is a microphone that will circulate around. We do want to capture any questions. So we'll kick it off with a very basic slide. What is intellectual property? There are 4 major types of intellectual property: patents, copyrights, trademarks, and trade secrets. Or as I like to think about intellectual property, patents are the concept. Copyrights are the tangible work, the thing. Trademarks are like a label. And trade secrets are really a formalized secret that you have within your company. Now, Gary, who is an inventor and an attorney, is going to be doing a much better job of explaining this than I am. I'm kind of trying to use shorthand in my explanations, but Gary can give you a lot more details.
Oh, yeah. Well, first of all, the Patent Office would frown on calling it the concept because you can't patent an idea. An abstract idea is a no-go. In fact, professionals, even patent examiners I've talked with, are no longer even sure what is patentable. It's a little bit in a state of flux. So we're living in interesting times, and I think you know that cuts both ways in patent world. But patents are essentially things or processes. Originally, the idea was anything that was new under the sun was patentable, and it's since gotten narrowed. You can't patent laws of nature, probably new antibiotics, if they're just a naturally occurring substance, are not patentable. Genes aren't patentable unless you do something strange with them, like insert one piece from one gene into another. Now, there's a little bit of a framework that I use to think about how each of these work, and it's a bit political, but it's true. With patents, a lot of the plaintiffs, a lot of the inventors are individuals, some corporations, some individuals, but almost all of the people who infringe patents are big companies. So patents last 20 years from the date you invent them. They're very hard to get and very easy to invalidate under the new rules that we have. Copyrights last essentially forever, thanks to the Sonny Bono Copyright Extension Act 50 years after the author's death. Interestingly, copyrights are, for the most part, owned by big corporations enforced against students who share a song and get sued for thousands of dollars. So that, for me, is a little bit of gives you a better understanding of why copyrights are so powerful, the remedies are so powerful, statutory damages are huge. Trademarks are just to prevent you from getting confused as to who is the source of the goods. I mean, you don't want to go to a store and not know who made the thing that you're buying, and that's all a trademark is. Trade secrets, interestingly, as they're weakening patents, they're strengthening trade secrets. And the Senate today, Senate committee passed out a federal trade secret law, which would be the first time, if that passes, that we have a federal framework for trade secrets. But one of the things you're going to see, especially in biotech, as things become not patentable, and a good example is there's a company called Ariosa that developed a fantastic way to avoid miscarriages, which is instead of doing amniocentesis, you get non-cellular DNA floating around in a pregnant woman's plasma. You look for paternal DNA in there, and once you identify the paternal DNA, you amplify it. It turns out the paternal DNA is attached to the maternal DNA because it's the baby's DNA. So you no longer need to do an amnio, and that was held by the Federal Circuit just really recently to be not patentable. So if they knew it was not patentable before they filed for a patent, I'd almost bet you that they would have done that test in secret, and no one would know how to do it, and it wouldn't be part of the public knowledge like it is now. So, but you are seeing a shift. Patents are going to shift to trade secrets. Copyrights, I think, are just going to keep getting stronger and stronger.
And so I'm going to provide a couple of links. One is to a nice history of patent law. And in fact, what Gary talked about, how they're moving to strengthen trade secrets, is interesting, because in the history of patents arose because there were family secrets, glass blowers, things like that, and if the family was wiped out in the plague or something along those lines, you would lose that knowledge. And so the idea of having a patent law where you would teach the public so the public knows, so that the idea isn't lost, arose out of that circumstance. So we're going from only secrets to creation of patent law, and then in recent years you've seen a weakening of the patent law, and now we're shifting to strengthening trade secrets.
In fact, Michelle Lee she gave a speech at CES this year and called patents the grand bargain, which is you tell us how to do it and we'll let you be the only one who does it for a very short period of time.
And there's also another link if you want to really dig into IP basics. There's one on the Association for University Technology Managers website, so we'll provide that link as well. Are there any questions about IP basics? Because we're going to now start into more strategies, the importance to startups, the importance to biotech companies, things like that. Okay, if you could wait for the microphone so we make sure we capture your question.
I was just going to briefly ask if you could comment on, with regard to what you just mentioned, the shift towards trade secrets and, VCs and angels evaluating companies based on what IP they have and what patents. How does that evaluation change? I guess, do they take that less into consideration? Are they willing to more go off your word on, okay, I have a trade secret and so forth?
So, Greg, do you want to take on how investors are viewing trade secrets and patents?
Yeah. So I can tell you that, for instance, in our portfolio, one of our most successful exits was a software company that actually was pure trade secret. Nothing was patented within that. So we aren't biased. Some investment firms are very highly biased towards patents themselves. We happen not to be. But we have to understand the balance between the patent, what it can provide, and then the trade secret. The reason we love trade secrets is if you have the right people as an investor, what we're looking for is some kind of sustainable competitive advantage, because we put money in today and we have to wait a certain period of time before we can get our money out. What we have to get comfortable and have confidence in is that during that period of time, you'll be able to maintain that advantage, that lead over somebody else. And so one of the questions we ask is, if someone were to know of your idea, how long would it take them to kind of either replicate it or reverse engineer what they think it is? And if we get confidence that you have a reasonable length of time and that you have the smartest people to do that, then we'll still take the bet on you.
Now, there is one little trick to it, which is it used to be that patents were never published until they issued. And so if the patent never issued, no one ever knew what you disclosed. That rule has changed, but provisional patents are never published within that first year. In fact, it's some 18 months after you initially file that they would be published. If you never file the utility patent or you abandon it before publication, it's never published and it's still secret. So you can actually preserve the right to get a patent and hold the trade secret for some period of time. There's some slight risk that someone at the patent office will break the law, but it's a good option. I mean, I've recommended that to people.
And just to give kind of a university perspective, the university is built to publish. So we have, when businesses approach us and say, can you preserve a trade secret, I talk about the freedom to publish and how we just aren't able to accommodate that. But in general, trade secrets are very powerful for a business and can add a lot of value. I think you had a question?
By the way, a lot of what's happening in big data right now is very heavily trade secret.
So my question is that what are some of the most successful and profitable patents that you have seen on your career? Because like you said, patents become more and more less important as trade secrets.
So at UCSD, some of our biggest money winners, money earners are, and help me remember these, but Erbitux is a therapy that rose out of UCSD and some of the research here. And most pharmaceutical therapies do very well in the marketplace and can provide lots of return to the university. That we had a few others. I think within UC, there's a hepatitis B out of either San Francisco or Berkeley, I can never remember. There's a hepatitis vaccine that is also very successful. And I think a smoking cessation therapy out of UCLA has earned quite a bit of money for UC. I hope I'm remembering all that. I have some coworkers here who are judging my work.
And actually, the value question is something that's really interesting. I'd say of that list, trademarks are far and away the most valuable. If Coke or Pepsi gave me their trademark, I mean, unless you have a patent on cold fusion and it actually works, there are very few patents that are going to be worth more than the top 10 trademarks. So if I had to trade for something, I'd want a top 10 trademark. Copyrights, just because they last so long, have an enormous amount of value. Interestingly, copyrights are almost a loophole in the grand bargain. The idea when they created copyrights was, well, you create the work and you give it to the public, and you make it public, and they have to pay you to read it or use it. But with object code for computers, you can't really figure out what they're doing or how they did it. You can decompile it, it's very difficult, but the copyright still covers it. So there's no public disclosure. So it's sort of an interesting loophole where we sort of forgot the purpose of copyright law. But the most valuable patents, interestingly, now are different than they were 5 or 10 years ago. One of the ways you could tell which patents were really valuable 5 or 10 years ago was the EFF's patent busting list. The top 10 patents that they wanted to bust were probably the 10 most valuable patents. Since the Supreme Court changed patent law, that list, maybe half of them is going to be invalid. So it's really in flux. I think anyone who pretends that they know what's the most valuable patent now has not followed what the courts are doing.
And I think, correct me if I'm wrong, but trademarks, to add to their value, trademarks in theory can last forever.
Oh yeah, they're permanent as long as you keep using them. Yeah. But you do have to be careful. You have to continue to protect them. So if you see someone infringing the mark and you're like, okay, yeah, that's not going to work. And that's why you actually get companies that are fairly nice sending cease and desist letters, and you wouldn't expect them to. I mean, really nice people, but the lawyers are like, no, you got to do that or your trademark
You have
goes
to
away.
go through the process. Any other questions before we move on? Okay. So why is it important? Why is intellectual property important at company startup? And here we have our first advisor. I'm not going to read these quotes. I invite you to read them. What I'll try and do is reduce them down to a bullet point. And I think what Ken, who recently had his company acquired, is saying here is start with the value proposition and then center your intellectual property strategy around your value proposition and then work your patents out from there. So ask yourself, how are you going to solve problems of your customer? And you may be surprised at where you can invent that isn't necessarily in the core technology, but helps the customer. I don't know if either of you want to.
No, it's, I mean, just remember, it's not your lawyer's job to figure out what is commercially valuable. And so you may give this enormous disclosure to the patent prosecution lawyer, and that patent lawyer, if you don't give them good enough direction, they're going to claim stuff that has no commercial value. You're going to spend $20,000 to $50,000 and end up with something that you don't really care for and has no value. But building on the, you don't have to claim, I mean, what I would say is you claim the core thing if you can. So the main part of our business is this, and we will try to claim it. The things you can enable are a little bit bigger. You want to describe them in your patent application so that if it turns out as you're building your company that, oh wait, we thought we were doing this, but we're actually doing this, you've also described it and you have your invention date on file with the patent office for it. But then there are things that you can't enable. And this is sort of the secret sauce of protecting your company from patent lawsuits. So to avoid being a defendant is early on, disclose enough stuff to make those things that you can't actually do obvious so that someone else can't patent it out from under you. So you don't want to have, Gen 1 of your product is here, Gen 2 is there, you got those protected. Gen 3 is somewhere out here, and render as much of that obvious. Make sure your patent is well dimensionalized. You think through what are the use cases in 5 or 10 years. You don't necessarily, I mean, you're never going to get patent claims issued for those because you don't know how to build them. But the standard for rendering something obvious so someone else can't patent it is lower than the standard for getting a patent yourself. So that's a good defensive trick.
Many years ago, I was involved with a startup, and our main product was an automated microscope. But we spent an enormous amount of time thinking about ways to patent the disposable that was going to go along with that microscope, because that was the money engine for the company. I'll sell the microscope once. I'll sell disposables, things like cartridges and things like that, many, many, many times. So again, there's the core technology, but then there is all around that what is encompassing your value proposition.
Yep.
I see. Now, Greg, did you want to talk a little bit about value? Value for the startup and value for the intellectual property when you take a look at a company and a startup.
Being about how we ascribe the value of what the patent is? Again, it's about the competitive advantage. When we assess a business opportunity, there's 4 things we put value on. And I'll do technology last because it relates to the IP. We look at the team and the talent. Can they actually execute? Do they have the ability to attract the right kind of people? Do the resources exist? The third thing we look at, do they have the right business model? And can that business successfully scale and grow? Because ultimately, we invest in businesses, we don't invest in technologies. And the last thing is the timing. Is the timing appropriate, and do we think that we can get our money out in our lifetime that would satisfy our investors? But the technology part is the one that we often have to spend the most time on. Because it's the kind of thing that it creates what is called the competitive sustainable advantage. It's the thing that allows you to do something. And so when you as entrepreneurs pitch to us as investors, please don't spend your time telling us how many people cancer kills or how big the cancer market is, because we kind of know that. What we'd rather you spend your time doing is telling us what are the 2 or 3 things you can do that no one else can absolutely do. things that set you apart and that would be difficult for someone else to do. That's where the value of your intellectual property comes in. And your intellectual property is not only the widgets themselves, but your people as well. That trade secret is really intellectual property in the form of human beings that have stuff in their head. So really be able to kind of articulate that, because you've got to give us, when you think about it, our job as investors is all about risk, what we do. It's about risk identification, risk assessment, risk allocation, risk mitigation. It's what we do every day. The value of the intellectual property goes towards minimizing the risk we take and actually putting money into your business.
And so there are many misconceptions and myths about value, and some of our advisors address some of those. For example, patents. I think what Ken is telling you is that patents are only valuable if your business is valuable. And this is echoing what Greg said. If you have a very technical patent that talks about a construction technique for building a building on the moon, congratulations on your patent. Maybe it issues, but what is the business? It isn't necessarily just a patent. There has to be a business. There has to be a way to satisfy customers. Further, your business is about people. It's about relationships. And I think that's the point that Ted Daly, who is actually an entrepreneur in residence here at UCSD, that's the point he's making. Build partnerships, build relationships, supplier contracts, having some sort of regulatory exclusivity. These are things that build around the IP that is adding to your business.
Yeah, I mean, there's two things. One, we didn't talk about confusion about time. I would just say that may be an older quote, I hope it is, because we switched a couple of years ago to a system called first inventor to file. It is no longer okay to wait. File early, file often. If you invent today and someone else invents next month and they file the next day and then you file after that, they get the patent and you don't. So there's no longer the leniency there used to be where you'd invent it and you'd perfect it over time. You just don't do that now.
No, and I think the point John is making is know the time that is related to the patent process. If you file with the patent office, you do not immediately get a patent.
12 years is the record we have for how long we waited for one.
Yeah, and I mean, I think 6 years is what I tell people to routinely expect. Yeah. Now, there are some that can get in and out in 3, but it is a very lengthy process with lots of deadlines that you have to pay attention to. There's the paying attention up front, getting it filed, but there's also further timings downstream that you very much have to be careful of. When you get that letter from the attorney about an office action, pay close attention to the deadlines.
In fact, that's critical. The attorney doesn't know what your business plan is. The attorney doesn't know where your business is along that plan, if you've changed plans. If you did it right when you filed for the patent, you enabled the thing that you're now doing. You might not have claimed it because you might not have realized way back 6 years ago that that's what you wanted. So take over for the attorney and tell them this is what we want to claim. And what I found is a lot of times the objections the patent examiner have just go away when you change from the commercially non-viable one that you thought would be good to the one you want now. They usually have some other objections. But I also wanted to echo something Greg said, because it works also for patent examiners, which is, he said, look, you got to be able to explain really quickly why your invention is so awesome or why your product's so awesome. It's true for patent examiners. They often don't even understand. I mean, I literally had a patent examiner I was on the phone with for about 15 minutes, and we eventually realized that he thought I was talking about a robotic device and I was talking about a human. And I mean, he misread the thing. So what I've started to do now is just put a paragraph right at the beginning, one paragraph. Here's why this invention's so cool. Here's why you want to help me get it patented. I mean, it's really just, it's like a sales pitch.
And it's interesting because we had the group of patent examiners come here to the university and talk to us. And they said it's very valuable. If you're going through the patent process, it's very valuable to have an examiner interview. Now, if you can even get even further ahead, as Gary said, consider what you were going to say in that examiner interview and put it as your first paragraph, like you're talking to the examiner. you'll create for yourself a much easier time explaining the invention and having it go through the prosecution process.
And also, if your business fails, if you're trying to get VC by presenting your patents as sort of leading edge, if for whatever reason you need to monetize the patents, having the patent itself be a sales document, at least on the first page where you're talking about it in an exciting way, and then later on you do the enabling stuff, that's really helpful, because patents are a super boring read.
Page count is not necessarily to your advantage to have a lot of pages in your patent. If you have a 200-page patent, you're going to struggle to be able to sell the central idea because you've got 200 pages to work through.
And also, every single time your patent lawyer touches that patent, they're going to charge you for every one of those 200 pages because they're going to read through that thing. It's
Yeah.
not a cheap proposition.
And that gets to our next confusion, which is confusion about cost. So it's important as an entrepreneur, as a business person, know the upfront costs. Know what the expected costs are as you go through the process, and also know the unexpected costs. There are unexpected costs associated with patenting, especially if you get into somebody challenging your patent, so that this can then lead to a very expensive process. And maybe you want to talk.
Oh, yeah. I mean, it's, well, first of all, one strategy a lot of people are adopting is while the US patent system is sort of in flux and the federal circuit's figuring out what the rules of patentability are, for things that are kind of in the gray area that they've created, we're seeing more filings initially in Europe, say Germany, in Asia, and eventually you come back and you file in the US. So you file what's called a PCT, and you're initially pursuing it in another country. That's super expensive. I mean, that you really have to be sure what you're doing. But think about the whole patent life cycle, and that's something that I didn't, until I actually I got my first patent, and I realized that there wasn't a check with it. It was one of those moments where, like, I didn't think this through. Okay, it's sitting here, it's a beautiful ribbon copy, the signature, it's in color, and now what do I do? So it costs a lot of money to get it issued. After it's issued, if it is sufficiently valuable, someone's going to challenge it. The American Invents Act created something called inter partes review, which was supposed to make it cheaper. It hasn't really worked that way. It's about $500,000. So someone challenges your patent, they're ready to spend $500,000, and you, as a little independent inventor, are sitting there going, where do I get $500,000 to defend it? And that is before you even get to federal court. And federal court, even if you find a lawyer to take it on contingency, you're looking at, I don't know, $500,000 to $1 million in expert witness fees and actual hard costs. So there are a lot of businesses that have sprung up around this where they'll fund it, they'll take 50% and they'll fund it or whatever their deal is, but it is seriously not cheap. And this is a reason why the conventional strategy of get as broad a patent as you can, and a lot of very established patent prosecutors still do this. That's no longer a good strategy. You want a patent that's valid first, and then worry about how broad it is, because a broad, invalid patent is worse than no patent. So I've actually taken to I do examiner interviews every time, and I did one, it was yesterday actually, and I actually thanked the examiner for rejecting the claims. And I said, I appreciate it because I don't want an invalid patent. I'd rather you reject it than issue it if it's not valid. And then we talked about how I could amend them, and we sort of reached an agreement that it sure looks like I can amend it this way, and you'd have to do a new search. But it's no longer the patent world of 10 years ago. You need something valid, or you are in for inter partes review maybe a few times. It doesn't have to stop at one. You can be put in inter partes review 10 times. And after that, you still have to pay for the federal court.
So, we heard from Craig Andrews, who is a local venture attorney. We're also hearing again from John Bean, who is an entrepreneur in residence here at UCSD. And what John is saying is basically patent judiciously. Have an entire IP strategy and consider what could be kept a trade secret, which is not all that expensive. You don't have to go to the patent office for a trade secret. What can be patented, and maybe what should be published in order to put your competition at a disadvantage, because now something that maybe they could patent has been published. So just be aware that you are generating an expense. Now there's some intrinsic value to that expense, but you're going to have to realize that value many years downstream after it issues. So just, you're a startup. Mind your pennies and patent judiciously. We are going to hear later on that you should also patent broadly and create an extensive minefield, which is also true too. And that's the thing you have to balance, is this is an expensive process. Is it appropriate to spend as much as you're spending? So as an executive, think about that. Now Greg, in your experience as an investor, have you run across any myths, misconceptions about this process?
Not so much. Again, it's pretty straightforward. Our favorite kinds of opportunities are those that what are called picket fences, where you have core IP and core patents, and then trade secrets between them. So it literally looks like a picket fence. So that, because the thing you have to realize about a patent is when it is published, you've now disclosed what you're doing to the world, and you've made it available for people to look at and possibly work around. When you create these strategies where you've got these pickets, and then you've got the space between them with the trade secret, the chances of them connecting the dots, if you do it right, are much lower. So that's what we like.
I've heard it described as, in fact, I've used the concept of a wall of patents. Because if you just have a single patent, someone's going to challenge it. If you have 10 patents, the defendant or the infringing party is going to look at that and say, I might be able to invalidate half of them. Even if I get 9 out of 10, I'm still in trouble. So going after someone with just one patent is not really done as much as you'd think. This is also, it's yet another factor that gave rise to these patent aggregator companies, because if you got one patent, it's really vulnerable. If you have 10 patents, people will license it.
So, and patent aggregators are companies whose central business plan is to obtain rights to patents, and then they don't always create products. Sometimes their revenue stream is intended to just be the licensing of these third-party inventions that they've accumulated. So there are more misconceptions and myths. One
Let me just make one more point.
Oh, sure.
Too. The one mistake that we often see entrepreneurs making when they write their business plans or their business model is they don't put enough money into the budgets to cover a lot of these legals. They just haven't thought through that. So when you do this, it does make a sense for you to have conversations with people you trust to begin making sure you get the right kind of numbers in your budgets.
And the thing to be aware of is when you talk to your patent attorney, they may be very quick to quote, oh, the fee to the patent office is $2,000. But that's just one of many expenses that will be wrapped up in that whole activity. So make sure you get a complete estimate. When I talk to people, I say, if you're thinking about a US patent, think about around $30,000. But it could be plus or minus 15, or it could vary from that. But typically, think around $30,000. Outside the US, around $100,000, especially if there's translation costs. And I don't know if that matches your experience.
Those numbers are about right. It really depends on the content of the patent.
And not all of it's upfront. You probably would pay upfront to get that full application in around $15,000. But again, there's plus or minus 5 to 7K on that. Page count matters. Number of claims matter. The more pages, the more claims, the more expensive it is. Every step of the way, it can add cost if you have hundreds of claims versus 10 claims.
And actually, there's a whole interesting strategy with that, but they charge you extra for more than 20 claims. They don't give the patent examiners extra time to review the extra claims. So for a while, one of the strategies was file a patent application with 250 claims. They won't have time to review them, and they'll just grant it. I think that's incredibly stupid as a strategy, because you're going to end up with an invalid patent, and that's useful for no one except you'll have spent the money.
So another confusion is about the expertise required to be an inventor, to get a patent. And this may sound strange at an institution of higher education, But maybe, Gary, you can explain
Yes,
your thoughts on.
This is my favorite subject. So usually when I talk, I do a lot of presentations to kids in grade school before the education system kind of breaks their creativity. It's still there, but it is sure discouraged. Well, here's the deal. Everyone in this room can be an inventor, is an inventor. You probably, many of you have had great ideas and not the self-confidence or knowledge to move forward with them. What I've done, I've actually been writing a book, and so I have some case studies that I've been putting together. And let's look at some really, really successful people. Rockefeller was worth in inflation-adjusted dollars more than $300 billion, so the wealthiest human ever to live. He was in oil, had no background in oil. He was an accountant, a bookkeeper. He went to school for accounting. He was a bookkeeper. Then he was a grocer. And then he just kind of got into oil. But he knew about business. Da Vinci, right? He didn't have any license from the government to take apart bodies. He didn't have any FAA giving him permission. He didn't have a background in art history. But he did a lot of stuff. Literally, the Renaissance person. Steve Jobs, no background in computers, no formal educational background in computers, no formal educational background in industrial design. The one that illustrates the point, and then I'll tell you what the point is Jeff Bezos. He did, from Amazon, he does have a computing degree. So you'd think that that's really a good fit. He went to school, he learned how to do it, he built out the system. But Amazon's not a computer company, it's a logistics company. I mean, at peak, they're shipping, I don't know, hundreds of items a second. So if he thought that if he went to school and learned all about logistics, he would have been told it's impossible to ship more than a certain number of items in a certain amount of time. And he would have learned, it would be hard baked into him, this limitation. But it was wrong. So what we teach as rules are actually just really a shortcut to our assumptions. So the rule was you can't ship that many items at once was based on an assumption that you wouldn't put together the same system that Bezos did. So my recommendation, there's this whole movement in Silicon Valley where people are saying, well, just drop out of college, you won't get anything out of it. I think that's nuts. You do need the education, but if you want to be the world's best mechanical engineer and come up with terrific inventions in mechanical engineering, get a bioengineering degree. Don't become too much of an expert in the thing that's most interesting to you, because then you're going to learn the limitations. What you want to do is you want to know enough about a subject to know the possibilities, but you don't want to know so much that you think you know what you can't do, because that's what holds you back. And that's what we spend almost all of education, all of our education doing, is we learn what we can't do. And that's really a backwards way to do it. I mean, I'd say revisit every single time the rules, because the rules are just a shortcut to the assumptions, and the assumptions should be changing and always be challenged. That's my two pieces, and this is why I have 154 patents. I don't think, I mean, maybe I have 5 in the same area. I mean, most of them are in aviation safety. I've got cloud computing. I have distributed computing. I have gambling devices. I mean, I don't know enough about anything to know what I can't do, and that's what's been awesome. So that's my 2 cents.
Well, and that gets to the heart of really entrepreneurship, innovation, and disruption. If you're an expert at, we'll call it the status quo, congratulations, but are you able to break free from that and create the next unique, different, groundbreaking idea that nobody's ever thought of before? And so, don't get too wrapped up on expertise. Notice we talked earlier about the value proposition and solving the customer's problem. You want to be an expert at solving the customer's problem, and your patents will flow from that. So try to think of entrepreneurship in that way.
Right, you're an expert at your own ideas, is what he's saying. And if your ideas are good, run with them.
Right. And then the final thing is of confusion. This is again, trying to think like a CEO. Try to know enough. You're going to rely on advisors, your legal counsel, et cetera. But try to be conversant enough, and attending a talk like this will help, about the basics of IP. You can really hurt your cause if you stand in front and give a pitch and you start talking about how you're going to you're prosecuting your copyright registration for your trademark, and just presenting a generally confused idea about IP. Try to be conversant enough, but knowing that you'll eventually rely on an attorney to get the details right. But you, as a CEO, need to be able to stand up and be conversant enough about IP to talk about it intelligently.
And this is a little tougher than you'd think. Under the new rules, it may be that this example is no longer valid, but it did happen. The game Monopoly, I love because it's sort of a meta IP issue. They patented the game Monopoly. They have a copyright that's probably almost certainly still in force on the appearance of the thing, and they have a trademark on the name. So they had at one point 3 separate monopolies. The patent one is expired. It's tough to figure out when you're talking about IP. Sometimes, if you're the CEO of the company that developed Monopoly and you're trying to sell it to Hasbro, you could easily trip up and say, oh yeah, well we have a copyright that's expired, but our patent's still good. I mean, it would be very easy to get that backwards, just because they overlap so much.
So to help you out, you need to hire the right experts. And that, I think, Krista Minio, who was a senior vice president at Receptos, she talks about the type of IP counsel to get, and she focuses on their bedside manner. And I think that is the important lesson. Even in intellectual property, people skills matter. We talked about an examiner interview. You want to get that examiner interview going in your way in a persuasive manner. If you instead enter into let's say, an adversarial or combative relationship with your examiner, you're not going to succeed.
No, you'll fail. I mean, it's not that you won't succeed. Actually, I love the quote about bedside manner. I've always characterized it slightly differently, which is hiring a patent lawyer is a lot like marrying someone. The best partner for you is not the best partner for me. And you want your patent lawyer to understand how you think. So expertise in the subject, that's your deal. You will explain the subject to them. They just have to understand how you communicate. And you have to have a good rapport with them. And I continue to think there is no best patent lawyer in the world. There's no best patent firm in the world. But for me, there's the best patent lawyer in the world. For him, there's the best patent lawyer in the world. So it's very important to be willing to shop around different patent lawyers, and don't be afraid to leave that firm. If they can't sort of anticipate your thought and work well with you that way, you shouldn't be working with them, because you will get bad results.
Okay, so we're about to enter into a new phase, digging into real strategies for businesses. Are there any questions at this point? Yes. If you could wait for the microphone.
You talked a lot about invalidating patents.
Yeah.
How many claims on a patent do you have to invalidate such that the entire patent itself is invalidated?
Oh, you'd have to invalidate every claim to invalidate the whole patent. It's a little more complicated because patents don't run alone. They typically run in families. So I might file 3 provisional patents and then file an initial patent off of that, and then a divisional and a continuation. You can end up, there was a guy named Lemelson who invented the barcode, and he had, see, the people who know it are like, oh yeah, Lemelson. He figured out a loophole. He's probably the reason we have 20 years from issuance instead, or from filing instead of 17 years from issuance terms, because he figured out a way to keep these things alive for decades. And there were so many patents that you could invalidate 10 of his patents and it wouldn't have mattered. He had so many patents covering it. And it's expensive to invalidate a patent. So, but yeah, and this is actually one of the other reasons. Make sure that your claims aren't all the same. A lot of patent lawyers will do that, where they'll say we have a method to do this and an apparatus to do the exact same thing and a system that does the same thing. No, just have one claim that does one thing and make sure the other ones do other things, so that way when you do get challenged, they don't all get killed based on the same rationale.
Any other questions? So now we're going to get into the heart of some discussions, strategies for IP for a startup. Ken Denman, we're hearing from him again. And what he's suggesting as you run your company, regularly have sessions with your team. Basically, it echoes off of his original quote. Talk about the value proposition. Talk to your team about patents. Make sure everybody is thinking about your patent strategy. So it's a team effort. John Bean, who is one of the entrepreneurs in residence here, think about what you're going to do while your IP is pending. So you're going to file that patent, and they don't immediately give you the issued patent. It's going to take years. So think about what you're going to do. Are you going to maintain trade secrets? Are you going to are you going to publish, strategically publish, things like that? Now, Greg, in your experience, what are some successful strategies for startups as it relates to IP?
Well, we don't, to be honest, we don't get that involved with in terms of our advice to them, and one is get a good patent lawyer. But very often when the entrepreneurs come to us, they already have some strategy already kind of well laid out, and that's what they're really presenting to us. The time where we get or will ever provide advice is when the company pivots, when the company decides that what they were currently doing needs to look a little bit different, and then we may need to either amend the intellectual property or take the company in a new direction. But usually our investment decisions are usually made based on what the company presents to us initially.
You know, and if you can put together a little bit of early round money, a little bit of extra money, as a small entity for $2,000 extra, you can do something called track one, or like fast tracking your patent. It's great. You get to a final disposition within a year, either a rejection or an allowance. But it can bite you too. When they first came out with this, I thought, oh, this is awesome. So filed 8 track ones, and what I didn't think through was, oh, so now I have to pay the lawyers for 8 office action responses all at the same time 6 months from now, after I just paid them to file. So it's a cash flow piece, but if it really is urgent that you get a patent issued, there are ways to speed it along.
And John is also recommending something called a freedom to operate opinion. Maybe you could talk about patentability opinions and freedom to operate opinions.
I would never issue one, ever.
Okay.
There are too many sub-patents that are not published. There are submarine patents. I find this so often with my own, where I'll have a patent that's issued and I'll have a continuation, and the examiner cites art to me in the continuation I had no idea was there. And then you have to think, well, geez, does this even invalidate the parent? So with the advent of the internet, and if they ever make archive.org searchable, you're going to see mass invalidation of patents, because pretty much many ideas have already been thought of, half-assed, written about, and then thrown away by other people. But they've been out there already, and they've been hard to find until now. So a freedom to operate opinion, I don't know, as a lawyer, I would have a lot of trouble getting that past my insurance carrier.
How many of you know what they're talking about? Do you know what freedom to operate is? Just want to make sure that people. So why don't you explain to them exactly
Basically,
what that means?
freedom to operate means that there is no patent out there that you're going to infringe if you operate. And given that the phone in your pocket right now is probably covered by 50 or 60,000 patents, I'd say you have a pretty bad chance of actually having total freedom to operate in almost any area. This is one of the reasons why companies acquire patents. It's not just to protect their IP, but it's also for defensive use. So if a competitor sues you, you sue them, and typically you cross-license. And that's what you see these giant companies doing, where they'll each have a portfolio of, it's almost like they used to talk about nuclear war as strategic weapons, and they develop these strategic arsenals of thousands of patents, and they're both like, well, we don't want to destroy each other, so we'll just cross-license and we're done.
So,
go ahead.
So a freedom to operate opinion is something you can have your attorney do. It will be very expensive, and it's a very high standard that an extensive amount of research, because they're basically saying, you've described your product, there are no other patents that are going to read on that. And that is a very difficult thing to determine, and it's a very expensive process to go through. To a lower standard is the patentability opinion, where they will assess whether you have a chance of getting a patent. There may be other things that read on it, but you have a chance of demonstrating utility, novelty, and non-obviousness.
And subject matter eligibility.
Right.
Didn't used to be part of the talk, but it is now.
Right.
Now that said, as an investor, when we first meet with someone, we're going to be talking to attorneys to understand, we're going to validate from our own perspective what we think the potential freedom to operate with this technology. Because we don't want to spend too much time getting to know this company and spending our own money, falling in love with the company, if we think there may be a probability that they won't be able to get this. That said, when we do fall in love with a company and we begin going into deeper due diligence, we will often either require or we'll even share some of the costs of doing a freedom to operate in this, because it's too risky for us not to do this.
And the reason I really have trouble with the idea of a freedom to operate letter is it's a very, very similar process to challenging a patent. So we have this IPR, this inter-party review process, the $500,000 deal where someone challenges your patent after it's granted. The kill rate, when they actually accept a patent for inter-parties review, is well above 50%. So these are patents that the lawyers thought were patentable, that the US Patent Office thought was patentable, often the Board of Patent Appeals thought was patentable, and it turns out when it gets to IPR, it's not patentable. Same thing happens in federal court, where judges find things not patentable that everyone thought was patentable. And often the reason they find it not patentable is because there's another patent that beat them to it. So if you had a freedom to operate letter, it's just as vulnerable to that kind of, boy, we didn't know that art was out there, but boy, here it is. It's just as vulnerable as a patent is. So yeah, freedom to operate letters, I'd say, have importance, but it's no lock, for sure.
We'll continue with some more strategies for startups from our entrepreneurs in residence. Now, John Bean recommends having a strong non-disclosure form. So when you early on you're discussing your invention, try to get the other parties to sign an NDA, but also know that investors won't sign that NDA. Now, there have been some changes, and I think you want to talk about the American Invent Act and its relationship to NDAs, that, as a certain level of thinking was developed under the old rules. Under the new rules, you're going to have to change your business strategy.
Right. I mean, and this is the thing. If I sign an NDA with you, and you say, okay, well, I'm not interested in the product. Thank you very much. Then you call the person who cleans your house and have them call their cousin, and their cousin files for a patent. I will never be able to trace it back. And under the first inventor to file rule, it doesn't matter that I can prove that I invented it first before the cousin of the person who cleans the house. So NDAs are useful. I would say get them, because that way a company that you're talking with can't basically breach the NDA. But it is no substitute for filing at least a provisional patent application, because then you're guaranteed that you have a priority date that beats anything that stems from the NDA. Technically speaking, the pattern that I described where I tell him, he tells someone, they tell someone, they file, because the information originated with me, that should not prevent me from getting my patent, but I would not want to have to prove that. It would be really hard.
There's a question.
If a company, if you signed an NDA with a company and then had a brilliant idea about some invention that is going to dovetail with what they've disclosed to you, what's the situation there?
Depends on the terms of the NDA. One thing that I've seen inserted into NDAs, not often enough, is a residuals clause. It basically says, look, I'm going to tell you, you're going to tell me stuff, and I'm not going to use exactly what you told me, but I can't erase the fact that I know it. So if later on it informs something that I invent, you don't get to come after me. I've seen it. I don't know. know of any case where they litigated it. I don't know how it'd be interpreted, but it's a huge problem, and it's probably why they say, you know, the investors aren't going to sign an NDA. Because yeah, it's a trap.
Yeah, and some companies don't want to be exposed to any confidential information. These are companies because they want to be able to learn from what you tell them. And if you have the ability if that becomes grounds for a lawsuit, that they've learned from what you told them under an NDA, they don't want to learn that way, and so they're not interested in the information.
And
Actually, it's the other way around. A company had me sign an NDA, and then I had an idea that would relate to what they were disclosing to me as a sort of complementary invention.
Well, again, it gets into the terms of the NDA. Does it have that residuals clause, or does it bar your ability to, does it bar you from even patenting based on using the information they provide you? So you have to look at the details of what you signed.
there may also be, it depends which state's law applies, and some states, you know, prohibit certain things as a matter of public policy, but that's one of those, we just talk to a lawyer because it's going to be so individualized. One thing that's also interesting, though, is I was thinking about people who won't sign NDAs. Many companies, I know because I've approached some of them, will not even talk with you if you tell them you have a patent, because once they know about the patent, then it's willful infringement and you get triple damages and attorney's fees. And so I mean, I literally had a invention that I had a patent on, and I saw a very big company doing something quite similar, and I just wanted to work with them. So the message I sent them was, hey, you know, I'm an inventor, I have a patent that's really similar to this stuff. I just want to consult with you. Of course, you get a license to the patent, and let's just work together. I actually just wanted them to build out this product better, and you know, I figured create the relationship with them, and it'll pay off eventually. And they would not return my calls. So it's kind of become tough, because just knowing about something has now become a liability.
So I know we sort of didn't answer your question, but did we answer it well enough?
Yeah, sure.
Okay.
I don't know that. I'll give you the perspective from the investor, and I think that there's a lot of myth around investors signing NDAs or not. We don't sign them in the first meeting. You know, we tell people we want to know what it is your technology does, you know, who you are, what you do. We don't get into how it does it in the very first meeting. We'll take at face value that what you're telling us is true. But at some point, if we're interested enough and we're going to get to the point where we're doing deep due diligence and things like freedom to operate, we have to sign a non-disclosure at that point, or we almost always do. There's a lot of deals where you don't get to the next stop or next step without signing it. But we have to be reasonably comfortable that we're going to get married before we sign the non-disclosure. And the reason we don't isn't because we're mean people. It's because we hear so many pitches and so many ideas. Our firm alone, 2,000 deals and pitches a year. I can't possibly remember what you told me versus what someone else told me, what I read and what I heard. My mind's just not that good. So we just want to be fair. And as Gary was saying, very often if someone comes and begins presenting something to us, and it even has this scent of something that may be a conflict, like we've already looked at another company or we've reviewed another deal, we'll stop the conversation right there and completely be upfront and disclose that right away.
Now there is a quick story I could tell about why you do want an NDA, which is there's a company that, out of kindness, I won't name, but we were in talks with them about licensing a patent, and it was a pretty valuable patent. They had a streaming video patent that they were enforcing, and we looked at it, and the cast of infringers were almost all the same. Their patent was about to expire, and ours had maybe 15 years, 14 years left on it. So we told, look, instead of signing these people up for a 2-year deal, have them license both these patents and sign them up for 15 years, and so let's do a deal together. And they said, okay, well, they thought about it, we're not interested, so we had a deal pending with someone else. And it was about a week before we were going to finalize it, get a call from our lawyer, your patent's been put into re-examination. Well, that ended the other deal that we were going to do. And it's possible to put a patent into re-exam anonymously, which it was. They hired a law firm. The law firm on its own, for its own self, put it into re-examination. And I read through the whole thing, and right at the bottom of the last page in the footer was the file path, which included the name of the company we've been talking to. So had we had an NDA in place, and I figured we were protected because we already had a patent, but had we had something in place saying you can't use anything we're telling you to put us into re-exam or present to the patent office, we could have sued them. Instead, they blew our other deal.
And very quickly, the strategy that Tim talks about and the tip that he brings forward is something that we experience quite often in our office. You're a young company, your first patent issues. What do? Do you do a press release, tell the world it's a great event, or do you not tell anybody because you don't want to become a target? It's a decision you have to make. It's something you have to think about. Some companies simply don't talk about the patents that they receive because they don't want to become that target. Others announce it to the world in a press release. So you kind of have to think about that and decide what's right for your company. So we're going to move on from startups, strategies for startups, to strategies for patent-focused companies. When I say patent-focused companies, the typical example is a life science company. And here we have Chris Aminio saying basically patents are central to the life science company. And that is because they have such a long time before they can launch the product due to the regulatory situation. And so if your company is in that situation, you have to think about these things, and you have to look at what Ted Daly points out. Are my patent claims giving me a commercial advantage? Take a thorough review over the actual claims of the patent, because those things are key to your company, and ask yourself, are these really going to give me that commercial advantage? And then Jack DeFranco, who's the CEO of Targeson, points out in a patent-focused company, a life science company, the nuts and bolts things that you want to do with your employees, establish notebooks, have an employment agreement in place, things like that, that you definitely want to get nailed down in your life science company.
A little trick, by the way. I think the case was Stanford versus Roche, but everyone changed their license agreements. It is not good enough to say, I agree that I will assign to you all patents that I come up with. You have to say, I hereby assign them. And it's one of those gotcha moments, but literally, I think every university changed their agreements after that.
Right. We get into additional strategies, again, from our EIRs. And this is, create that minefield. Cover what you can, publish what will potentially mess with your competition. And these are actually fairly advanced strategies that you can engage in a startup, but really you're getting into more of a company that's been around for a few years. We'll move on to copyright-focused companies. Maybe the company you're going to build is in the entertainment industry. You want to be like Disney. If you were to look simply at Disney's patent portfolio, you probably wouldn't be that impressed. You wouldn't think it's a enormously successful company because they have a few roller coaster patents, some design patents.
Don't they own Pixar though?
Well, they now have Pixar.
They probably have some good patents.
Yeah, so you can buy a company with an extensive patent portfolio, but Disney Central was always built around copyrights and trademarks, and so there are strategies for copyright companies. And it's getting into kind of some interesting areas of what creative companies can do. If you look at the computer game industry, there's a whole entertainment broadcast network being built around people playing video games on camera, earning a living, earning six-figure incomes. All of them could be shut down by the computer game companies, but they don't. They don't because it's good advertising for their game. So there's a synergy there, and there's a lot of articles related to the creation of, I think, what's called Twitch and a few other streaming channels.
My 8-year-old knows them all.
Yeah.
She does?
Go ahead.
We'll get to this in a sec, but there is another gotcha thing here, and this hits many, many startup companies, if you use independent contractors to develop your software or other copyrighted materials, under California law, they own the copyright. You have to have them sign a very specific, I mean, there's almost magic language that they have to sign in order to make sure that you own the copyright. It has to be a work made for hire, and this is one of those things, talk to a copyright lawyer or else this will totally bite you later.
Yep.
You had a question?
Yeah.
So my question is go back to back to the last slide about how like you create a strategy where you create a bunch of other patents to I guess cover your patents, like the main one. It's hard for me to see like an example of that like in your career. Like, can you talk about like one a patent that has been like that?
Well, it's a good question because I hadn't actually thought it through, but I drafted a patent application about 3 years ago, and the idea was it was a better mechanism to have coordinated decision making over great distances, and I always envisioned it as a telesurgery patent, as a remote surgical patent, and my co-inventor envisioned it as a way to determine whether you were going to have a drone strike or not. And so the question was, well, what do we claim? And so, in some of the claims, in some of the incarnations of it, we're claiming surgery, and others we're claiming, we're claiming drone strike stuff. So the fact is, we had a really good invention. We just didn't know, and we still don't know how it's going to be used. I suspect it's going to be used on the military side because my co-inventor is having those meetings, and I'm not. So I think he was right. But I mean, that's maybe as good an example as of things that are apparently opposite but aren't really. I mean, fixing people's bodies or blowing people's bodies up, and it's all covered with the same technology and the same patent. So if you're not sure where the technology is going to go, over disclose. And I think that was one of the slides, get the stuff out in the public domain. Well, once a patent is published, it's considered prior art retroactive to the priority date, to the initial filing date. So if you actually file for a patent, that's just as good as publishing it, just putting it out on the internet or something. So, except it provides you more protection.
And it costs.
And it costs, yeah. It does cost. So you could do it if the whole idea is just to get it published and to preserve the right to later do something. If you spend enough time writing it up, I mean, you still should use a patent lawyer, but you could get away with not. And it's better to do that than to get no protection. So patent lawyer will get you the best protection, but it's still better to do it yourself than not do it at all if you can afford the filing fees.
Thank you.
So moving on to trademark-focused companies. Here I just have some clever quotes from the history of trademarks. And really, it's all about brands. So you think of a business whose whole focus is on brand, you might think of something like Coca-Cola, Kleenex, Xerox, all the very famous brands that are out there. Those are very valuable. You can build a company just on a brand. So you may want to think about that. That may be the right way to go, is to build your brand and perhaps not worry so much about either copyright or patents. Maybe not, but try to incorporate it in your thinking. There are successful companies out there that are examples of really brand companies in the fashion industry and things like that.
There are also important uses for trademarks other than branding. I mean, as I agree, I mean, trademarks they're the thing. If you can get a valuable one, it's huge. But there are other benefits, like if I have the trademark on my name and someone tries to register it on a new domain name and register my name out from under me, even though I have the trademark, I can go use the ICANN domain name resolution procedures and probably get that domain name back. So I mean, there are these weird side benefits. It does run up against the First Amendment, though. So like if I had United Airlines sucks.com, they probably can't use their trademark to shut me down. I could imitate the look and feel of their site even, and probably I'd be okay under the First Amendment. So there are limits to what you can use a trademark to stop, but they're very few. Actually, it's really the First Amendment is the limit.
Greg, in your experience for startups, how important is branding?
Branding is everything. For the obvious reasons. One is because it sets you apart. Again, it's part of that competitive advantage. But today, in a world where we're all clamoring for the attention of consumers and buyers, you have to stand above the noise, and so branding is a kind of core part of it. Now, there's sometimes when you're building something that's kind of more of an Intel Inside model, where you're a part of something. And Larry Ellison once said, very early on, you have to decide if you're a product, a feature, or a benefit of something else. So not every idea that you've come up with is meant to be a standalone product that needs to be a brand. You may be a part of something else, or something that goes in something else that enhances it, or becomes a feature of it. And in that case, brand may be less relevant, but in our opinion, it would probably also be less valuable.
Look, the font of all wisdom, Homer Simpson, said it really well in the first season of The Simpsons. There's a scene where he's mowing the grass, and he says, "Oh, you got all this crabgrass." He says, "Oh, crabgrass. Everyone would love it if it had a cute name like elfgrass." Something to it. I mean, you need to have the right name, you need to have the right image, you need to have the right brand. There's a reason that Facebook succeeded where, no one even remembers the name of, what was it? MySpace failed, right?
See, I already forgot it.
Yeah, I mean, exactly. MySpace was not memorable. Facebook was.
So we're scheduled to go to 7. I have 3 slides left, so I hope you'll be patient and let us work through those. Are there any questions at this point? Okay. So now you've started your company, you figured out the focus of the intellectual property. You want to think about scaling the company. And again, we have some of our experts giving you some interesting strategies, which you can think about as be diligent, be responsible, be open to other ideas. And I think this last one, where the benefits of not invented here, is an interesting thought. As you grow your company, can you reach outside of your company and obtain some new ideas? And I am being very self-serving because, of course, what we do here at the university in our office is license ideas to other companies. So I'm actually asking you to consider licensing some inventions, either from us or from other sources of new technology. But as you scale your company, you may find that you cannot invent fast enough to grow with the company, and you have to reach outside for those technologies.
Google has a program, which I don't think got much press outside the patent community, where they'll give startups a patent. It's sort of a starter patent, and I mean, it's a strange program, but there it is. So they're available. One thing I'd say about having a single person oversee all patent-related matters, it's a good idea to have a single point of contact, but make sure they understand their job isn't just to get a huge number of patents, it's to get the right patents. One solid patent that is valid, enforceable, and covers your core business is worth more than 100 patents that don't.
And then as you scale up your company, you become a large company. And you start to get in some of the advanced strategies of doing things, as we've talked about. Some defensive tactics of publishing. Also, when you start to license your own intellectual property, try not to tie your hands too much. And that's some of the advice that we have from Craig Andrews and actually some information that we got from the web. Because
I'll tell you this, I mean, not only do you not want to tie your hands, but be careful what you do with your intellectual property, depending on your exit strategy. If you send demand letters based on it, some people won't buy it. If you litigate it, it might become unsaleable. I mean, people might look at the file wrapper, the file history from when you first got it and find something in there. If there's questions about if the assignments are valid, that you can't sell it. So you have to really, I mean, you really have to pay attention to what you do with the patent, because it will impair your ability to monetize it later.
Now, as part of the life of a company, you can sometimes reach an unfortunate end. You may have to wind down operations. You still have your patent estate, you still have your intellectual property. It is a value to the company, and it is very complicated once you get into bankruptcy court, what happens to that intellectual property. And I think you have an interesting story.
Oh, I have a great story about this. It was 1999, 2000 or so, and we were running a web hosting company in San Jose, and it was pretty big. It was one of these big free web hosts, and at the time, they were hoping would eventually be Facebook, was the globe.com, which was two 20-year-olds in parachute pants running a company. So already you could see why this might be a bad idea to do a stock sale with them, but we did do a stock sale. It was like $25 million worth of Globe stock at $17 a share, but it was locked up for 6 months. And at the end of the 6 months, they were trading at 70 cents a share because the bust happened. So we ended up bankrupting the company that we had just sold its only or primary asset of. And we realized that our patent lawyer had inadvertently sent us assignment forms that assigned one of the patents to this company. All the other patents were going into a separate company. So we now had a company that was bankrupt, and there was a bankruptcy trustee to deal with, and they owned the patent. So rather than try to, tell them, oh, it shouldn't have been assigned, we were like, okay, we'll just take it as it is. We told them, look, just pay for the prosecution of the patent, get it issued, and you'll be able to pay back all the creditors, and we'll still walk away with money. And the trustee thought we were trying to pull a fast one. And so he said, no, I'm not going to do it, but I'll tell you what, you pay some money in, we'll just give you the patent. And that's what we did. And it ended up, we were right, and he was not. So it's, the two lessons we walk away from, which is one, put your patents in a separate entity. That's critical. If you don't want your patents to die with the company. So it was critical for us. It may create trouble if you're trying to get funded or go public or whatever, but for us it really worked. And the other is just pay attention to how the patents are disposed of in bankruptcy, because if the trustee, who has no background typically in the field, doesn't recognize the value, you can get it back at a bargain. It's not what we set out to do. We didn't even want it back originally because we wanted the creditors to get paid. But when he refused to monetize it, he let us.
And just from the university's perspective, we do ask, if you're licensing from us, try to terminate that license before you go into bankruptcy. Otherwise, it's our technology is being tied up by your bankruptcy, and it's not the best for the technology. Usually, most people within the business world want a technology to succeed. Having it languish in the hands of a bankruptcy court doesn't help anyone.
They're very ill-suited to understand the tech in a patent.
Yeah.
I mean, they're probably the worst suited, actually.
Yeah.
They're good with finances, not so much with tech.
So do we want to end up with some final comments? And then maybe open it up more to questions?
I'd rather hear from them, yeah.
Let's go straight to the audience. And anyone have any more questions, or do we answer everything? Oh, good.
In terms of licensing a patent from the UC system, so I already have a patent that, as Inventor on at the school, and I'm trying to license it right now. What advantage do I have as the inventor on the patent, licensing it from the UC as opposed to another company trying to license it? Do I get a better licensing agreement or anything like that?
Good question.
So the thing that the university has to worry about is its reputation in the community. I've been invited to lunches where local entrepreneurs have scolded me for giving special deals to insiders. And really what we try to do is we try to be fair to everybody. As an inventor, often the case is you're the only one who sees the value. We try and take it out and show it to people. It ends up being so early that other companies just don't appreciate your invention. So the natural thing that happens is we do inventor-based startups. So often you're the person who is going to start the company and get the deal. Currently we have, I think, very favorable terms through what's called our open flow program. And so I would invite you to take a look at that. That's something we've announced to the public, and it's available, and it's intended to encourage startups, especially inventor startups. So the details are on our website, but it's a pretty good deal for starting a company.
You know, there's a benefit too to your licensing your own patent that probably is not apparent to people who do licensing. But as the inventor, you could destroy the patent easily by just saying the wrong thing once. I mean, it's really interesting. If you characterize the claims in a certain way, that could be how they get stuck. If you go tell people, hey man, I was telling everyone about this for years and finally the university filed on it, well then you got the 1 year on sale bar and your patent's probably not valid. So if you're licensing someone else's patent, you don't know if the inventor is crazy or not, and you don't know if they're going to do something to get even, or if they're mad at the university for not paying them enough. But pretty much you know how you're going to behave. So it's a lot of certainty that you're buying when you license your own stuff.
And you know, I quoted all the numbers earlier, the number of patents, the number of licenses. And I will say that for a company to be a success, the inventor is usually involved in some way.
Yeah.
Otherwise, I am licensing a piece of paper that somebody has to read and then learn from and then implement. There is such a loss of efficiency to excluding the inventor from that process that most companies, most business people don't want to do that. They want to know if the inventor can be engaged in some
I
way.
mean, Greg, would you I mean, isn't it a huge benefit when you're thinking of acquiring a company that you acquire the team as well as, I mean, I always figured it was the team.
There's no hard and fast rule. A lot of times you've got, it depends at what stage of the technology. Obviously the inventor, we want them to come in, particularly if there's more development to do. If it's a completely, finished piece of art, the value that the inventor may add after that may or may not be relevant. What we generally like about inventor entrepreneurs, if they're the right people, is the passion, because you can't replicate that in someone else. Probably no one's going to be as passionate about what you've done as you. And what we want to do is try to find a way of unlocking that. And maybe finding the right person to work with you. Particularly, historically, a lot of inventors don't make the best business people. Occasionally you do find them. So putting an inventor together with a great entrepreneur can be magic. But every once in a while you find wonderful inventor entrepreneurs, and those are golden. You can find them.
So I think just to wrap up, I would invite you to try to take advantage of the services our office provides, take advantage of the services here in the basement, and I wish you good luck with your new ventures and your innovations. I think we have a questionnaire for you to fill out, and we will be sending out these slides probably tomorrow to everybody who registered for this.
I don't think my email address is on the slide. Maybe you put it on there. It's
I'm
just
happy
my
to do
name,
that.
Gary@Schuster.com. Happy to talk with, I maybe unwisely love talking with inventors and end up spending a lot of time providing what turns out to be unpaid advice, but usually I learn as much as I teach, so please feel free to contact me with questions.
Thanks.
All right, thank you, everybody.
Thanks.